I'll be done.
Yeah. So,
Okay.
infos for
See y'all on vacation.
A couple of those guys.
Can you imagine? I'm sorry, I'm not
If there was surveillance.
we have like 10 cases here. You want to go and come in tomorrow?
Yeah.
I'm only going to be in there probably every other week.
Right. Hey, what's up?
Everyone, please remain seated. Come to order once we get in session.
Okay, let me get Mr. Batey out here, please, so we can see where this thing stands. Wait a minute.
I'm sorry.
All right, Mr. Batey is in the courtroom at this point. I did receive a motion to withdraw by Mr. Robinson, but this matter is on really for two purposes. One, his motion to withdraw, and the scheduled sentencing hearing. And it's my understanding that the state is ready and wants to go forward on the sentencing hearing on July 15th. Is that correct?
That's correct, Your Honor. We have already booked flight for the victim and also hotel room. He's working around their schedule to be here on the 15th. And the state's ready. I think the pre-sentence report's been done. The state's filed appropriate paperwork. We're not asking for consecutive sentencing. The only issue will be the range of punishment for the court to decide.
All right. And Mr. Robinson, notice that you had filed a motion to withdraw. If you would state your reason, and I will ask a few questions of you as well.
Yes, Your Honor. Good morning, Your Honor. I am the attorney of record in this matter. Your Honor, following the trial, and I guess it was approximately 4 weeks ago, I received information from Mr. Batey's family that they were attempting to hire Peter Stryantz to work on the appeal and also work on this, represent Mr. Batey in the sentencing hearing. I had follow-up phone calls with his family and some text messages. I was notified, I believe, the week around the 15th or 16th that Mr. Stryantz had in fact was being hired and that he would be getting in the case. I subsequently received an email from Mr. Batey's family indicating that Mr. Stryantz again had been hired and that he preferred to handle this matter alone, and that we were being asked, Ms. Teasley and I were being asked to step aside. Subsequent to that, I believe on the 27th or 28th, I received an email from Mr. Stryantz indicating that he was taking the case, he had been retained, and that he would be representing Mr. Batey in the sentencing hearing, and he would be sending over the appropriate order to substitute counsel. I believe it was on the afternoon of the 28th, Your Honor, I received another email from Mr. Stryantz indicating that he had contacted Mr. Thurman about continuing the sentencing hearing from July 15th and asking if, Mr. Thurman in the email indicated that the state was not willing to continue the case, that they had arranged everyone's schedules, arranged flights, and that he would not be willing to reset the sentencing hearing. Mr. Stryantz subsequently emailed back and said that he would not be representing Mr. Batey and that it would be left to me and perhaps Ms. Teasley. And then I received an email from Mr. Batey's family saying, as you see, Mr. Strands can't do it, let us know what you need to do or what we can do to help you. And at that point, Your Honor, it was, for me, I had not filed a motion to withdraw prior to that. It was clear that Mr. Batey and his family wanted someone else to handle the sentencing hearing, and I did not file my motion to withdraw just because I thought it would be a smoother transition with an agreed order to substitute. Subsequent to finding out that Mr. Strands would not be getting involved in the case, here we were basically 2 weeks out from the sentencing hearing, and knowing that Mr. Batey preferred to have someone else do it, I thought it was appropriate for me at that point to file my motion to withdraw. I have discussed it with Mr. Batey. Mr. Batey would like to address the court if Your Honor is willing, and he has some thoughts he would like to share with that also. But at this point, Your Honor, I'm asking the court to grant my motion to withdraw.
All right, well, I think first and foremost, this matter was scheduled for a different time, earlier time, and I believe the parties may have reached an agreement. I'm not certain with regard to continuing this matter. Is that correct?
That's correct.
Okay, and then we set it again for the 15th of July. As stated by the state this morning, they are not seeking consecutive sentencing, and so the only issue is the range of punishment. You know, I have presided over hundreds and hundreds and hundreds of sentencing hearings, and it doesn't, one doesn't necessarily need a new lawyer for a sentencing hearing. Sentencing hearings are simply just that. I think, you know, any criminal defense lawyer can do a sentencing hearing. And in this particular case, Mr. Robinson, you are attorney of record. I was reminded this morning that Ms. Teasley was never really retained. She basically volunteered to be an attorney of record. She had sought state funds, but the rules don't allow for a second attorney to be paid from state funds on a non-capital case. Therefore, she was not paid. In any event, this matter is set for the 15th. It shall remain on the 15th, and we will have the sentencing hearing on that particular day. And you, as attorney of record, you will have to stay on the case until after that date, and then I will entertain your motion to withdraw. And then if Mr. Strands wants to come forward and work on the appeal, I'll be more than happy to have him do that. You know, it's up to the family whether they hire him to do it or anyone else for that matter. But this matter is set for the 15th. It's going to be heard on the 15th. Okay? Anything further from either side?
I think Ms. Teasley will be required to be here since she did enter.
I'm going to send her an order to be here, yes, because she operated as attorney of record. All right? All right, thank you all.
Your Honor, Mr. Batey does indicate he would like to address the court.
Well, he can do that at a sentencing hearing, but at this juncture, this is a whole different kind of matter. He can address the court during his sentencing hearing. He's more than, I'm more than happy to allow him to do so. All right?
Okay, thank you.
Okay, I'll take a 5-minute break so people, and then I'll come back and hear other matters.
All right. We'll bring a 5-minute recess.
Yes, sir.
Is Larry back there? Yeah. Where's my department?
Trying to get Jeff signed now. I know.
those hours, even though her motion to dismiss, so we moved it to tomorrow. Is he still here though?
Yeah.
If he's here, I'll see what Roger thinks, maybe we can arrange it today.